as a part of our lecture series, we have been hosting many lectures with experts from different areas. And today we have Dr. Laishram Malem Mangal, who is an assistant professor of public international law at Symbiosis Law School under Symbiosis International University in Pune. Then I'll be hosting today, we will be hosting a lecture on the topic center-state relation in India, a perspective on Manipur. So I'll be co-hosting with Michael Jackson Pabum, and he'll be introducing a brief note on the ARC LA library. Yeah.
Okay, hi everyone. Good afternoon. Thank you so much, Priyanka. My name is Michael Jackson, and currently I'm an intern at the ARCLA in Ph.D. And talking about our library, it was established in 2005 and became a public library in 2022. And we have members from different walks of life, including students from humanities and STEMs, researchers. We have artists, journalists, doctors, professors, and many more. ARC is a vibrant hub of people from different backgrounds where we regularly gather to organize a variety of events, both online and offline, such as lecture series like this, art exhibition, workshop, and many other cultural events. And the library holds a wide collection of books from different disciplines. And you can also find a rare Manipuri historical manuscript from 16th century to the present in our library. So to learn more about our library, and stay updated for an upcoming event, you can follow us on our Instagram account, and you can become a member of our library by simply fill up a simple Google form. I will share our ARC Instagram account link and library membership here in the chat box, so you can check it out. Yeah, that's all about our library. So I ask Priyanka to take over and proceed the session. Thank you so much, everyone.
Thank you, Michael. I'll just give a brief note on Oja Malem. So he has been working much on the status of Manipur, right from Manipur, the status of Manipur, right from the merger agreement of 1949 to various, like topics like the AFSPA, Armed Forces Special Power Act 1958, and his main interest lies in legal theory, state legitimacy, and public international law. And considering the political situation of Manipur right now, we have President rule imposed, Article 356 imposed recently, and the suspension of our state legislative assembly as well. And we want to know like how the federal structure of India, like in relation to Manipur works, and how like the imposition of Article 356 has been has impacted the overall social and political condition of Manipur. And considering the kind of situation we are having, and it's a very pertinent topic to understand the overall federal structure of in India, and particularly I would say asymmetrical federalism that we have been exercised with the Constitution of India regarding Article 371 in context to various northeastern northeastern states of India. So it is a privilege and honor to host Dr. Laishram Malem Mangal, to know your expertise so that we can learn more on the prevailing situation. Thank you. Then you can move on to the lecture.
Okay, thank you, Priyanka. Thank you, Pebam and Oza Somerset, for reaching out to me and inviting and having me here in the monthly online lecture series. And thank you for that brief introduction of my interest, of my works, a few works I have had. So, yes, thank you again to Advanced Research Consortium, Library and Archives, Imphal. And the topic that has been assigned to me for today's program is on center-state relations in India, a perspective on Manipur. I was trying to go back to history to understand, in order to understand the structure and the format, the system of center-state relations, or what we call as quasi-federalism, because India is not purely federal in the sense that the United States of America is. So Maybe we begin by Government of India Act 1935. Visiting this instrument can throw us light upon how the British administrators had conceived a political system of federating the political units of that time. So we have two system of entities, political legal entities. One, British provinces directly administered by the British administrators in the form of under the governor general or governor system, and then the states, or as we also call as the native states or princely states. So under the Government of India Act 1935, a federation of India was envisaged to be established. However, it could not be a successful scheme. It was not successful, so it was a failed project. But the importance of the Government of India Act 1935 lies in the way that relation, the constitutional relation between the federal government and the states were planned to be executed. Say, for example, the states were always, I think it would be appropriate to insert here the point that states had always occupied a very important role in the politics of the Indian subcontinent after, before, and even during and after the British rule in the continent. So we can say that under the scheme of the Government of India Act 1935, the states retain all the elements of sovereignty, or we can call as internal sovereignty. The way in which states should establish relation with the federal government were based on three subjects that we also know by referring to the instrument of association, which princely states, including Manipur, executed in on 11th August 1947. So these were defense, external affairs, and communications. And apart from these three subjects, under the Government of India Act 1935, the states were internally sovereign. The federal government could not interfere into the affairs of the state. So this is one importance, political importance of the scheme. And then if we see the coming of the before the enforcement implementation of the Indian Independence Act 1947, we also need to understand the importance of the British policy towards the princely states. What were the position of the British imperial government towards the state at the lapse of British paramountcy. So we have seen in history that there were many British missions in India to study the feasibility of independence, or the transfer of power as we call it. Second, the nature of relationship that the newly constituted or established countries, the Union of India, Dominion of India, and Dominion of Pakistan, and the relationship with the princely states who were pre-existing entities before the coming of British in the Indian subcontinent. So here we remember the Cabinet Mission Plan of 16th May 1946. And the importance of this Cabinet Mission Plan lies in the fact that the British imperial government have clearly stipulated certain important principles after the lapse of the paramountcy. So one is that paramountcy cannot be retained by the British government, or nor transferred to any successor government, implying the dominant government of India or the dominant government of Pakistan at that point of time. And second is that the princely states were given the liberty or the instructions, we can say, to enter into negotiations in order to accede, in order to join to the newly created dominion and their constitution. And third is that they also made it very clear that the states were fully autonomous. They can accede to the dominant government only three powers with respect to defense, external affairs, and communications. Then another important instrument was the Memorandum on States, Treaties, and Paramountcy, submitted to the Chamber of Princes by the Cabinet Mission on 12th May 1946. And this instrument is also very fundamental in understanding the political and the legal status or personality of the princely states during 1946 and 47, even before the implementation of the Indian Independence Act 1947. So basically, the Memorandum on States laid out certain cardinal principles on the status, political, legal status of the states, saying that with the lapse of paramountcy, the sovereignty and the independence of states had been restored, and all the rights and obligations that were in existence with the British government through treaties, engagements, and senates come to an end, and the British government is released, as well as the states have been released. All the states were released from any obligations owing towards the British, and so vice versa. And saying that the memorandum continued to state that uh, the states have now the liberty to negotiate for federal relationship with the dominant government of India, or failing this, to enter into particular political relationship with the newly created dominant government of India. So then third, we can also recall the statement made by His Majesty's government on 3rd June 1947, where the Majesty government has reaffirmed the position of the British government towards the states as contained or as laid down in the Memorandum of States of 12th May 1946. Now, we also, I think that we also need to understand the position or the policy of the Indian nationalists towards the states. We remember that on 5th of July 1947, the States Department was created with Sardar Patel as the head and BP Menon as the secretary of the department. So the basic function of this department was to bring the states into the Indian fold, to work towards integration of the states, to build up, to create constitutional relations between the states and the newly created Dominion of India. So we see that on the same day when the States Department was created, the states were called upon by Sardar Patel and even Mountbatten, the then Governor General, to accede to the Union of India, to accede to the new constitution. So by this time, if we try to understand both the States Department and the Governor General Mountbatten, they assured states of their internal full sovereignty, saying that apart from the three subjects, the states have full sovereignty and the Union government would not encroach upon their internal sovereignty. So this was the position. And now if we come to the making of the Union of India beginning 1947 with the implementation of the Indian Independence Act, we see this provision for independence in Section 7(1)(b) of the Indian Independence Act. And this is a provision that is very important for the states, saying by this section, all the states with the lapse of the paramountcy have become independent, and the options for joining India or Pakistan through the instrument of accession has been provided in Section 2(4) of the Indian Independence Act. And all the treaty relationships, engagements, and sanats, whatsoever that were in existence between the British government and the states come to an end. So this instrument is important. And now we come to standstill agreement. This is because I don't know how many of you would be like family. I mean, the way the structure that I have prepared for today's topic, I have prepared in this structure in the system. So I go back to history out of necessity in order to understand the present state of center-state relations within the Constitution of India. So stencil agreement is there before the instrument of accession, and stencil agreement was designed to continue the status quo, in the sense that the administrative relations prevail between the British India government and with the states. And so it was a transitional, we can say, an agreement, and an agreement for transitional governance, to maintain the relationship between the two entities, until a new concrete relationship is established under instrument of accession and merger agreements that would follow. So the importance lies in that, to maintain the status quo, not altering the relations which was established under the British rule with the states. And second, now coming to the instrument of accession. Instrument of accession, if we look back to Government of India Act, it was also provided the instrument of accession as a very important tool for states entering into relationship with the federal government of India. So, in that same manner, the Indian Independence Act of 1947 also provided this instrument of accession under Section 2(4) of the Act. And because of this, many of the states entered into or entered into the Union of India to join the Union. And now we also remember the importance of the Memorandum on States 1946 and the Cabinet Mission Plan. All these instruments, all these policies of the British, they clearly laid down that the states at the end of the paramountcy, having restored their independence, they have the liberty to enter into negotiation with the Union, and they can join the Union of India. But it was not an imposition; it was rather it was a matter of discretion, because the states have been restored their independence and sovereignty. And this point, if you try to see some of the Supreme Court cases during 1954 and 1993, in a number of cases, the Supreme Court had reaffirmed the status of the states during 1946 and 47, saying that all the princely states at the time of the Indian Independence Act were politically independent and sovereign. So this is the importance of this Indian Independence Act and the instrument of accession. Now, if we see again very categorically, we recall certain provisions of the instrument of accession, especially Article 7, saying that the states do not commit to accept the future constitution of India. For example, Manipur executed the instrument of accession on 11th August 1947, but it does not make Manipur committing to accept the future constitution of India. And then another Article 8 of the same instrument also categorically provided that the sovereignty of Manipur or sovereignty of any state is not affected by acceding to the instrument of accession or to the dominant government of India. So these are two important provisions of the instrument of accession when we discuss the position of states within the Union of India. We should refer to, we try to understand from history. Now, these Supreme Court cases that I have mentioned, I can state a few. That is Virendra Singh versus State of UP 1954, State of Gujarat versus Vora Fidali 1964, then Sri Raghunath Ganpat Rao versus Union of India 1993. There are many cases. I am picking up only few in order to refer where the Supreme Court had maintained that the princely states in India during 1946 and 47, especially after the implementation of the Indian Independence Act 1947, they were sovereign independent entities. So all the princely states were independent and sovereign at the lapse of British paramountcy, that is 15 August 1947. Now we come to the Constitution of India 1950. So before coming to the position of states or the relation with the union government, we try to understand the basic nature of the Indian state. Article 1 defines India, that is Bharat shall be a union of states. So when it defines as union of states, it implies that the entity, the political system known as the Union of India was constituted by states, by various states. And if we refer to the Supreme Court Constitution, Supreme Court rulings of from during this period of 1993, from 1954 to 1993, it gives the implication that all these states were sovereign and they come to join the Union of India by executing instruments like the instrument of accession or the merger agreements. So around 600 princely states at the lapse of British paramountcy, most of these states, and they have integrated themselves first. There were instruments of merger, small states merging with larger ones, and there were many categories of states. There were states in the sense of the term, politically and legally, which were very small in size and which were not viable to function as independent units. Therefore, the States Department under Sardar Patel, they work out a plan to integrate these viable into viable political units. So, series of integration and mergers took place before actually these states joined India formally or officially in the form of even the membership of the Constituent Assembly of India. So um, this was the state of affairs when we try to understand the Union of States, India as a Union of States under Article 1 of the Constitution. And here we also can remember what Durga Das Basu, an eminent constitutional expert of India, tried to explain Article 1 of India's Constitution, saying that India is an indestructible union composed of destructible states. So here we again try to understand this context, his justification or his characterization of the Indian polity when he tried to say India is an indestructible union composed of destructible states. Article 3 comes into picture. Article 3, because of which the Parliament of India has the power to amend, to modify, to alter, or to separate, to carve out new state from the adjoining states. This power is given. So it literally gives the implication that the Parliament is supreme as far as the integrity of the states is concerned. The territorial integrity of states is amenable, is subject to change under law by the Parliament. So in India, under the 1950 Constitution, the states do not have a right to territorial integrity. This is what Article 1 and Article 3 try to say. And this has been the trend. If we try to look back the history of how states have been reorganized on linguistic, on cultural lines, or even community lines, then we have seen that this reorganization of states is a manifestation or evidence of what Dr. Durga Das Basu tries to say about the Indian, about the character of the Indian Union. So then another important point that I should insert here is about that the states, in whatsoever manner they have entered into the Union of India, either voluntarily or through merger agreements, like in the case of Manipur and Tripura, or say even Sikkim, to certain extent, these states, all the states in India do not have a right to secede, that is to leave the Union as and when the state decides. So that is not available within the Constitution of India. Again, to emphasize this point, let us also try to bring one case of the Supreme Court of India decided in 1963, known as the State of West Bengal and Union of India. This was a case where the question came before the Supreme Court with respect to the right of state for the natural resources found within the territory of a state in West Bengal. So here the Supreme Court had ruled that the states in India are subordinate. That is, they are not sovereign. They are not on an equal footing. They are subordinate units of the union, and they do not do not enjoy sovereign rights over their natural resources. So meaning thereby any resources, natural resources found within the territorial limits of a state, say for example in the case West Bengal, that resources are subject to the sovereignty of the union. The union government is fully sovereign. It can exercise any power to acquire, to develop that resources. So that was the position stated by the Supreme Court in 1963. So now with these things, the basic point that I'm trying to make is that the Union of India that has been established by the Indian Constitution during a span of time beginning from 1946-47 till 1954, or let me say till 1975, as the case of Sikkim was acquired very late. So the process of state making within the Constitution of India was continuing in character, and so this state making process, which was continuing in character, can be again explained better by referring to Article 2 of the Constitution of India, wherein we find that the territory that may be acquired by the government, by the parliament. So Sikkim is one good example here. Sikkim and the relation between the dominant government of India were dependent upon an instrument of accession of 1947, and based on those terms of the instrument, 3 subjects have been surrendered to the dominant government of India. But around 1973, 1974, problems started having in the relation between the Chogyal, the institution of the king, monarch in Sikkim, as it has been called there. The nature of relationship between Sikkim and India worsened. So there are stories that I would like to share here when I started speaking about Sikkim and the way it became a part of India. So Sikkim had a monarchical form of government, and through instrument of accession, it had a relation with Union of India, especially in the matters of education, in matters of economy. Now, this Sikkim was associated as with Union of India as under the arrangement known as Associate State of India. But if we look back into the history of the states entering into relation with the Union of India since 1947 or 49, there is no arrangement known as Associate State of India. So it was one new peculiar type of relationship that the Union Government of India maneuvered to establish with Sikkim. And in 1974, a plebiscite was held where the people of Sikkim voted in favor of joining the Union of India, and the Parliament of India enacted the 35th Constitution Amendment Act 1975, and out of that, Sikkim became a part of India. So this was one case. And now, if we try to understand situations of states which have resisted or which have taken the position of maintaining their independence, not joining either Pakistan or India, we remember the case of Jammu and Kashmir. We also remember the case of Hyderabad, Junagadh, Travancore, etc. Now, if we come to the case of Jammu and Kashmir, Article 370 is there. So Article 370 signifies the treaty which was instrument of accession, the relationship that was established between Union of India and Jammu and Kashmir. It was based on the instrument of accession. And in the case of Jammu and Kashmir, this instrument of accession was ratified by the Jammu and Kashmir legislature and by the Parliament of India as well. So insertion of Article 370 into the Constitution of India was giving a respect, was showing the constitutional status where the Jammu and Kashmir state lies within the Constitution of India, what is its status in relation to India. So it was a very symbolic political, we can say, provision within the Constitution. And as regards to the revocation of Article 370 by the enactment of the Jammu and Kashmir Reorganization Act 2019, the Supreme Court had also upheld the constitutional validity of this Reorganization Act. However, the Supreme Court advised the Union government to restore the statehood to the Jammu and Kashmir, Union Territory of Jammu and Kashmir. It seems that in that ruling of the Supreme Court, the unification of Union Territory of Ladakh into Jammu and Kashmir is not possible. So Ladakh may be, in the scheme of things, as the Supreme Court ruled in that decision, Ladakh may be a separate entity from the entity of Jammu and Kashmir if in future it would be reverted its statehood back. So here, there are issues of international law. As an international law student, as an international law researcher, my perspectives are that the instrument of association was a treaty between two independent entities under international law. So, if we try to understand Article 370, Clause 3 of the Constitution of India, it says that the President of India can notify the revocation of Article 370 entirely, but that notification must be based on recommendation of the Constituent Assembly of Jammu and Kashmir. So here, the political circumstances in 2019, where the Union of India, the Union Government of India, had tried to transact it, manufactured this recommendation of the Jammu and Kashmir Constituent Assembly, or we can say the people. It seems to be fraught with certain deceitful techniques. The procedural, the manner in which Jammu and Kashmir has been incorporated, the way in which Article 370 has been revoked, lacks procedural fairness as per the law, as what Article 370 Clause 3 provides, and as per the law of treaties. Because when at the time of Jammu and Kashmir and Union of India entering into the instrument of association, the international law of treaty was applicable. So treaties must be respect must be observed in good faith. So there is a principle in international treaty law known as pacta servanda. So any treaty that has been entered or concluded between two entities must be observed. One one party cannot unilaterally change the terms of the treaty or abrogate the treaty. So that is my take on Article 370 and how it has been revoked. Now coming to Hyderabad, the issue of Hyderabad went before the Security Council of the United Nations. However, we have seen the political scenario on the ground where Sardar Patel and Mountbatten, they maneuvered to coercively obtain the consent or pressurize the ruler of Hyderabad to join India, and Hyderabad finally surrendered, and militarily it was occupied, and Hyderabad became a part of India. Now, again, same case in Travancore also. Travancore did not want to join Union of India. It wanted to maintain its distinct independent existence as before British came, but there were situations, and here let me point out the Congress political party. During that time, not the Congress party of what we have today. The Congress was one such political organization that had worked very hard for the integration of India. And many of the princely states like Travancore, they were manipulated by the Congress party. They invested huge money, and they met people. They exploit the sentiments of the local people against the ruler, and then they insurrected revolutions against the ruler, and that is how the state's ruler were compelled to accept to the invitation from the Union government to join the Union of India. So like that, these things went on. And if we try to understand Junagadh was a princely state where the majority of the population were Hindus and the ruler was Muslim. But when the issue of joining India or Pakistan came, Junagadh was allowed by the dominant government of India to hold a plebiscite. So a plebiscite was held on 20th February 1948. And again, if we look back to Pondicherry, and the territories of Mahe, Yanam, and Kale, they were territories under the French occupation. And by the time India's independence, the issue for joining, whether to remain with France or to join India, uh, a plebiscite was allowed to take place in Pondicherry on 18th October 1954. And because of this, Pondicherry and its territories joined India. And Sikkim, like I referred to in the other instances, that Sikkim became part of India through a plebiscite held on 14 April 1975. So these were the situations how states in India have become part of India or integrated into the Union of India. Now, if we come to the quasi-federal structure, we remember certain provisions of the constitution that gives overriding power to the parliament. So parliament has overriding power to make law over state subjects in national interest, or during proclamation of emergency, or when two or more states request to do so. And parliament also has the power to make law to give effect to treaties or international agreements which the state has signed or ratified. Now, let me come to the basic structure of the constitution. The idea of basic structure was developed by the Supreme Court in Kesavananda Bharati versus State of Kerala, 1973. And the importance of this principle is that, as per the Supreme Court, certain values of the Constitution without which the Constitution would not stand alone. So it means to say that there are some values, there are some principles under the Constitution which, if taken away, would erode the very fabric of the Constitution. So here, discussing in the context of center-state relations, the principle of basic structure has been celebrated on the one side and critique on the other. Why celebrated? Because the center-state relations as we have today in India is more of central dominance over the states. States' autonomy is least respected. That is why we refer Indian constitution or Indian political system as more of unilateral, unitary, with more unitary features and less federal features. And again, why it is critique on the other side is because of the fact that when we say that a certain principle or feature of the constitution has been included into the basic structure doctrine, then it is unquestionable. It becomes unamendable. So let's say the less autonomy given to the states because of the basic structure doctrine is unquestionable, then the states autonomy becomes very limited. It cannot raise its voice to assert more autonomy towards the union government. So this is the critique side of the basic structure doctrine. Now, there is one important point here. One Supreme Court judge retired from Assam, B.L. Hansaria. He has written a book with the title, Do We Need to Write a New Constitution? So referring to India. So his opinion is that India's constitution, as we have present, the relations between the union and the states is not satisfying, especially in the context of the states where there are political demands for autonomy, more power, streamlining of the relationship, including the features of governors' rule, like Article 356 itself. So this is one question raised by one of the retired judges of the Supreme Court belonging to Northeast region. Now, uh, these are some of the instances where I try to explain the structure of the Indian Constitution in the context of center and the position of states. So here, again, let me again cover this point of the Constitution Amendment, especially the 26th Constitution Amendment Act 1971. Now, here, why certain princely states who were very vocal in the Chamber of Princes around the time of the lapse of British paramountcy, uh, they feel that there has been a breach of faith, breach of trust. Their faith and trust has been betrayed by the union government, is because of the fact that when the states were persuaded to join the Union of India, they were given assurances, they were given certain conviction that your internal sovereignty would not be disturbed at all by acceding to the Union of India. So, by the 26th Constitution Amendment Act 1971, the privy purse that were reserved for the rulers of these princely states were abolished. So that was one act that had uh, 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 we can say hurt the sentiments of the princes, of the rulers of these states. And with the reorganization of states that I had also referred to in earlier, it has certain purposes other than from making or constituting or reconstituting viable subjects under the Union of India. One of that very important function was to obliterate the historical and the political identity of the states which existed before the merger took place, or before before the states joined India. Now, see, uh, as part of the special status provided under the constitution to certain states, including the Jammu and Kashmir, we also can remember, we also refer to Nagaland, the state of Nagaland, Article 371A. So here we see the provisions given under this 371A are basically reflection of the 16-point agreement 1960 between the Union of India and the Naga underground groups. So Naga customary practices are protected. Naga administration of justice, civil and criminal, according to Naga customary laws, are protected, and the resources, including land and resources, are protected. Any law of the parliament cannot have direct bearing or application into the state of Nagaland unless assented by the assembly of the Nagaland state. So these are the provisions that have provided relating to the states of Jammu and Kashmir and Nagaland. Now, uh, see here, coming to the present state of Manipur's relation with India, let me bring out certain points here. Manipur's relation with India had been based on certain treaties and agreements, and Manipur signed the Instrument of Accession, the Stencil Agreement, and the Merger Agreement. Merger Agreement becomes the most controversial instrument through which the relation has been defined between Manipur and India. And there are political questions, political insurgencies are there, challenging or contesting the legitimacy of the Indian state over Manipur since 1949. So here we also remember the political status that Manipur had around the time of 1947. Manipur had its own constitution, 1947, and Manipur had its own popularly elected government 1948, we saw the elections taking place from June-July, during June-July 1948, and the then titular king of Manipur inaugurated the Manipur parliament on 18th October 1948, and 1949 we saw the merger agreement taking place on 21st September, and from 15th October 1949, the administration of Manipur was taken over by the chief commissioner. So we have these incidents as well as political realities. Now, if we try to understand the rootedness of Manipur from the perspectives of international law, how can we understand Manipur in relation to the Constitution of India from the context of international law? Because if we try to see entry number 19 of the first schedule of the first schedule of the Constitution of India, it recognizes the existence of Manipur before the commencement of India. So it is there in the Constitution. Entry 19, first schedule of the Constitution of India, has defined Manipur as a territory under the Chief Commissioner's province before the commencement of the Constitution. So these are certain pointers towards the existence, towards the historical and the political identity of Manipur before the Constitution of India came into force. And here lies the importance of the political protest, the current that has been in existence since 1949. Why certain quarters are taking a position that the nature, the procedure in which Manipur become a part of India has been very undemocratic or against the principles of international law. So with issues, there are various issues lauded to make the relation or the policy of the union government towards Manipur unhappy or undemocratic. Say, for example, the demand for ethnic-based homelands, the demand for the bifurcation of the territory of Manipur along ethnic lines. So here, Article 3, the applicability, the question arises as to the applicability of Article 3 to Manipur. How can a provision of a constitution become applicable to a state which was in existence before the Constitution of India come into force? So there are questions like this regarding the viability or the inviolability of the territorial integrity of Manipur. There are questions addressed towards international law, especially we recall the principle known as ut possidetis juris, which was developed by the International Court of Justice in Burkina Faso, Mali, 1986, stating that the territorial boundaries of states at the time of independence must be respected and it should not be violated, it should not be changed. And the objective or the purpose of this principle, ut possidetis juris, is to secure the boundaries at the time of independence from colonial rule and to minimize or reduce wars between ethnic groups, because we have seen in many parts of the world at the time of independence, ethnic groups, they fight for political power. Like in the case of Somalia, in Sudan, Sudan has been broken into two pieces after independence. So again, even in the case of Yugoslavia. So in order to prevent fratricidal wars or domination of power based along ethnic lines or linguistic lines, this principle has been upheld by international courts and international law experts. So this question is always associated with Manipur because of certain ethnic exclusive politics, or we can say identity politics based on ethnicity, has come up during 1960s and 70s, and that continued to have effect on the political existence of Manipur. And these are few of the points. And here, with respect to Manipur's boundary, let me also again add you, in addition to ut possidetis juris, There is a principle in international law known as the objectivization of boundaries established or recognized by treaties. For example, the Treaty of Yandabu, 1826, and the 1833 Jiri Treaty between the British Commissioner Grant and Manipur's Gambhir Singh, the Maharaja of that time. The boundary of Manipur were recognized. So any boundary that has been recognized or established by a treaty are made permanent and sacrosanct according to this principle of international law. However, uh, as regards to the question of Manipur, if we refer to 1833 boundary, there are questions. Then there are issues that the boundary of Manipur that existed around 1833 has been reduced to a very considerable extent. So we can see that the principles of law or the position of law is not independent. They are affected by politics of the time or by the geopolitics of the time. So that is one reality that we see. And if we try to think about India-Manipur relations, a perspective on Manipur, on the way that center-state relations should be as it is or should be progressive, then we can think about modifying the center-state relations on the basis of the Instrument of Accession 1947, or maybe allowing Manipur people to exercise their right to vote on the question of Manipur, like in the case of Junagadh, in the case of Pondicherry, and in the case of Sikkim. So they may be democratic, and it may sound a kind of bringing an end to the political question as far as India's relation to Manipur is concerned, the question of India's legitimacy over Manipur is concerned. So these are a few observations, and even if if in case any revision of the relationship between India and Manipur is not possible as with respect to the Instrument of Accession or holding a referendum, an amendment to Article 3 of India's constitution may calm down the sentiments of the people of the state. This may be a viable option for the Union of India. So these are few perspectives from my end with respect to the existing center-state relations in India and from the experience of Manipur. Now, I would like to maybe invite comments or any feedback.
Thank you. India as a nation state have, engulfed many of the princely state who was a sovereign authority of its own at that time. Then, considering this, you have explained about international, positionality in law as well, how the kind of, insurgency which exists in Manipur and all over Northeast regarding the demand of several autonomy that has been there, and you have also explained how, like certain angles of international law can be positioned in this insurgency to have a kind of alteration to the arrangement that is there in present context. So yes, it was very interesting and eye-opening as well. We got to know several other aspect of like how this legality or litigation works. I would like to invite any of you who wants to ask question to Oza Malem. Please feel free. And one of the question I got in the chat box is by Raskumar Panthoiren. He typed, he is asking one question. He said the question of ownership of natural resources has been a sensitive issue of indigenous communities within India and featured in political negotiations between the union government and political entities. Would this political negotiation, especially the Indo-Naga negotiation case, open up further constitutional debates to accommodate the sanctity of community-based natural resources ownership? Yes, Oda Malam, you can answer to
Okay.
that.
Okay. Yes. Thank you for this question. This is very important in the context of center-state relations, and when I highlighted the case of a state of West Bengal versus Union of India. This was also pertaining to the ownership, the right of the state over natural resources found within its territory. So even if the case of Nagaland leave this Indo-Naga political framework or any agreement that may come in the future, the present structure under Article 371A is one provision that guarantees the non-interference, or we can say the internal sovereignty of the state of Nagaland, the government of Nagaland, towards its resources. It is very specifically and categorically given under this provision of the Constitution, saying that the Parliament do not have the power to modify any law or to make any law relating to land or natural resources. And there were certain incidents during 2012 and 13. Uh, 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 One notification was brought out from the side of the Nagaland government, inviting tenders for the development of oil fields in the state in Nagaland. Then the union government responded with saying that the resources within Nagaland state belongs to the union. The union has the power to make law or to develop or to commercialize those resources found within that state. Here, the Nagaland state withdrew its notification inviting tenders for that. So now what we can see here is that if we look into the seventh schedule basically divides the legislative powers, the lawmaking powers, union list, state list, concurrent list. So this power of the parliament to make law for the development or for the commercialization of natural resources is provided under list 1, especially under entry 54. If you look entry 56, 57, you will find that power of the union government to make law concerning natural resources, including mines and minerals, petroleum products, then water and water valleys, rivers, etc. These are domain of the central government. And apart from that, Article 248 of the Constitution of India gives the residuary power to the union government. Whatever subjects have been allotted to the states are defined under list 2, but any subjects that have not been allotted to the states remain with the central government. So this residuary power lies with the union government. And if we look back to Government of India Act 1935, residuary power vested to the states very contradistinctly. And now, if, say, for example, in the case of an agreement coming up between the Naga insurgents and the Government of India, I cannot say of certainty that this right of ownership would be respected by the Government of India in case such an agreement comes up. Maybe because the precedent in India's constitutional jurisprudence regarding the ownership rights is not favoring the people or the community. See, for example, many development projects of the state affecting the people, community towards their ownership rights of the resources. Say, for example, right to fishing, right of making a livelihood out of their community resources are not supported by the precedents, by the jurisprudence. There are many legislations that have been enacted to the disadvantage of the local communities. So I don't see such a kind of certainty, or we can say guarantee, guaranteeing the rights of the community or the people towards their resources. I would like to answer like this.
Sir, I got one question from Waikholm Sena. So he asks, is there any tool to protect Manipur from segregating under Article 3? Besides that, could you repeat the standstill agreement?
Segregating Article 3 might be, maybe it can be rephrased that how Manipur can be protected from the applicability of Article 3. Maybe I can take that way. That is the one reason Manipur, when I put up this point that, see, India's constitution acknowledged the existence of Manipur before 1950. That is there in entry number 19 of the first schedule to the Constitution of India. If you read the first schedule, entry number 19, you will find that provision. That provision signifies certain realities. One is that Manipur was an entity that was in existence before the coming into force of the Constitution of India. Second is that if we try to read the political and historical import of this provision, entry 19, is that Manipur existed as an independent entity before the coming into force of the Constitution of India. So we refer to the period between 1947 and 1949, that is before the merger agreement was signed, or the Manipur Administration Order October 15, 1949 was executed by the Chief Commissioner. So that was one instance. Now, the question is, how do the lawmakers, the legislators, the policymakers bring this to negotiate for the inapplicability of Article 3 to Manipur? That depends upon the, what I can say, the integrity of the politicians, of the lawmakers. There should be a way to communicate to the government of India that on the background of these historical political realities, Manipur became a part of India, and the first schedule of India's constitution testifies this historical and political identity of Manipur. So that can be a very good ground of negotiating to the government of India to to amend Article 3, so that Article 3 becomes inapplicable, inoperative with respect to the state of Manipur. And instrument of accession, instrument stencil agreement. Okay, stencil agreement does not hold a very good way of understanding the relation between the Union of India and Manipur, or for that matter, with any princely state, because it was an agreement that do not define any political relationship. It was more in the nature of maintaining the status quo, especially in administrative relations as existed between British India and the princely states before the independence. So it was of not so much of importance to discuss about. More important than any of the agreements is the instrument of accession, and if we have to include merger agreement. So this instrument of accession became the basis of establishing constitutional relationship, I mean to say political relationship with the dominant government of India and the states. So instrument of accession is very important.
Yes, sir. I have two more questions in the chat box, but before this, I wanted to ask one question regarding the Article 3 that you have mentioned, that it can be amended, like in the near future. But my query is, like, is it possible to do solely for the state of Manipur? Like, is it possible that, Article 3 can be amended solely for Manipur itself?
Yes, there is. See, we discussed about Jammu and Kashmir, Article 370. And with respect to Jammu and Kashmir, not only Article 3, but majority of the constitutional provisions were not applicable. But the President of India, from time to time, enacted constitutional orders, and many of the provisions of the Constitution have been made applicable to Jammu and Kashmir. Now, in the case of Manipur, it depends. The possibility of amending Article 3 to the extent that it becomes inoperative to the state of Manipur depends upon the approach of our policymakers, politicians, and the people, because the way in which Manipur became part of India is a historical and political reality being reflected in the first schedule of India's constitution, entry number 19. uh, it is with us. The central government will not come and say that you have a context, you have a historical and a political context to say that Article 3 is not applicable to us. So it depends on us. It is we, the people of Manipur, the politicians and the policymakers and the people, to assert that right, that historical right. So Manipur deserves that assertion of that right, and the amendment of Article 3. I would say like that. I would like to answer like that.
Okay, thank you. There are questions lining up, and I'll pick up one question, which is by Rajkumar Panthurin again. So he asked, are autonomous district councils of Manipur or sixth schedule provisions state within states? This is one of the questions. Then second, he asked, how can we understand the role of governor here, an elected constitutional position in the functioning of these autonomous bodies in terms of center-state relations?
Yes. First, the Autonomous District Council of Manipur, there is a difference between the ADC that we have today in Manipur and the provisions of the system of sixth schedule. There are lots of difference. Say, for example, in the case of the ADC, we have a state law, the Autonomous District Council Act is there. So they are not state within a state with respect to the ADC, because the power and the functions are delegated from the Manipur state legislature. They are part of the state lawmaking process, and they do not override the authority of the state legislature. So these ADCs are part of the state legislature, and they do not override the state lawmaking authority. They are not state within states, but giving some form of autonomy where the state government would have a you can say supervisory role is not a problem. But if we say about sixth schedule provisions, yes, sixth schedule we understand as sowing the seeds of creating state within state, because the authority in the hill areas would be directly under the central government, and the state's role is curtailed through the position of the governor. So here again, the role of the governor becomes important, whether it be ADC or in the six scheduled areas of other states. In the northeast, the governor has been given a very special responsibility with respect to the administration and the governance of the tribal areas, hill areas. And this has been, if we try to understand, this has been a feature of the way the princely states were administered by the British government. In the case of Manipur, the Manipur Darbar, the president of the Manipur Darbar, who happened to be a British official, used to have the governance, the responsibility of the governance of the hills or the tribal areas. So this is a kind of, you can say, the trust deficit from the perspective of colonial administration still continuing in the post-independent era, post-colonial era. So these are here, and giving some sort of autonomy is not a problem, provided that the state legislature and the lawmaking policy and the executive authority are not overrided. I do not see any problem in giving autonomy or strengthening these institutions.
Thank you. I'll take up one last question. I mean, not the last question, but this is the last question in the chat box. This is by Dibanjali Biswas, and she or he, I don't know. So he like she has also asked about ADC in Manipur. So She asks, what are the legal procedures, not community-based resolution, but what is a legal course of action to begin a more sustainable communication process between ADC, Manipur Center, and who has the authority to do that at the moment?
Please repeat the question again.
Uh, she's asking what are the legal procedures, not community-based resolutions, but what is the legal course of actions to begin a more sustainable communication process between ADC hyphen Manipur hyphen Center, and who has the authority to do that at the moment? I think she's more of asking the relationship between the ADC and Manipur state and the center government, and like at the moment, at the present political situation, who has the authority to do
Yes, basically this ADC or whatever term we call regional district councils, regional councils, autonomous councils, they are within the framework of the state government. But when we talk about sixth schedule, it would be not in the framework of the state government. It would be entirely through the governor, and it is under the control of the central government that is there. But at present, since president's rule has been imposed, every administrative affairs are being dealt with directly by the central government. So it is clear it is not with the state government, it is with the governor. It is with the governor because governor is administering the president rule on behalf of the center.
Okay, sir. The next question is from Paikomba Wangkem. So he is more like he's asking a question in relation to Kapo Bailey by MP Sanajawa in the Parliament session based on merger agreement with Union of India. Are we going to get back the lost Kapo Bailey? What are your views?
Uh, we have a history of Cabo Valley becoming part of Manipur and again losing it to Myanmar. Uh, when we read the history of Manipur written by different scholars and professors, especially Gamumai Kamai, Professor Gamumai Kamai had written that in 1470, Manipur's king Kiamba had entered into an agreement with King Kekomba of the Pong state, the San state, the Pong kingdom of then Burma. And because of that, Cabo Valley became part of India. Cabo Valley was given to King Kiamba. And but we also have seen many records that this valley has been a point of contestation, controversy. Myanmar and the Manipur kings, they always fought over the position of this valley. However, legally, if we see, it was under the possession of Manipur. But in 1834, there is an agreement called Agreement regarding the compensation for Cabo Valley. So in this agreement, Cabo Valley was ceded to Burma by British authorities. There were political circumstances how Cabo Valley was ceded to Burma. And then to compensate that cession of Cabo Valley to Burma, 500 Sika rupees was fixed annually to be given to Manipur as compensation. So that is from the point of law. But the recent controversy by the statement made by MP Sanazawa in Parliament, I do not think that this issue would be easily looked into by the government of India based on his question in the Parliament, because there have been question and answers. There have been stain of the government of India regarding the same question during 1952, if I remember correctly, one MP from Manipur raised this issue about the compensation, whether the compensation is still in continuation or not. So yes, from the point of international law, and if we see the interest of Manipur being affected when neither the Kabo Valley has been restored back to Manipur, nor the compensation has continued. From that perspective, we have a very legitimate right and interest to pursue the matter. But given the geopolitics of the time, the circumstances under which Manipur is going through, a series of chaotic situation, political instability, I do not think it good to bring up this issue at this point of time. Maybe in future, maybe with a very good strategy, we can think about that. But at this point of time, I don't think it is a good idea to come up with this issue.
Okay, thank you. Then the next question is from Karlin Khangembam. He asked, since there has been some clear violation of international treaty law in context to the merger agreement, is there any way to make sure that such a violation doesn't happen? If there aren't any exact violation, please clarify it.
Okay. Violation of international yes law, especially the principles of treaty making have been violated. These are we observable clearly when we go through the treaty. If we see the merger agreement, the text of the merger agreement, you will not find any provision that is dedicated towards the development, towards the welfare of the people of Manipur, towards the political, economic, and social well-being of Manipur, except for the part that in Article 1, the Maharaja of Manipur sits the full and the final authority and the power for the administration and the governance of the state to the dominant government of India. So this point is one that the when say for example why merger agreement becomes very important apart from the procedurally the merger agreement, the way in which this agreement was concluded it become very clear that it violated the established principles of law, namely the way in which the consent of Manipur's king was obtained at Shillong. He was met into house arrest. He was not allowed to contact to his people, to his council of ministers in Manipur, and so it was a kind of total excommunication, cutting off all the communication, and he was not allowed to consult. So that was the first point of violating international law. Second, the use of threat. There were deployments of the Indian Sikh regiment and the Assam Rifles in Shillong as well as in Manipur around the time of the merger agreement in September and October. So basically, in international law, the presence of the military or paramilitary personnel of one state into the territory of another state without the invitation or request is occupation. So it is against the established principles of law. So threats or force were used by the Indian state, by the representative of the dominant government of India, especially in the State's Department, while trying to make sure that the Manipur king signed the agreement. These circumstances took place. Because of that, international law principles are violated. If we see at particularly the Vienna Convention on the Law of Treaties 1969, Article 51 and 52 talks about the invalidity of treaties that has been concluded by using any coercive measures, including threats or force against the representative of another state. So, according to the Vienna Convention on the Law of Treaties, the way in which the consent, the signature of Manipur's Maharaja was obtained was in violation of international law. And See, the way in which your question has been framed, to make sure that such a violation does not happen. Now the agreement is already over, and because of that, even though the agreement is contested, even though it has violated the principles of international law and even including the United Nations Charter, Manipur become a part of India. Whether we like it or not, it is a legal reality. So integration of Manipur legally is over because of that agreement. But yes, there are. I'm not saying that the future of Manipur outside India or is not open. It is open, but how do we proceed? It depends upon our approach. And by saying this, I am also not hinting towards any politically charged movements for independence of Manipur, because there are forums, there are ways, there are options how we negotiate even with the government of India. Government of India coming to realize the issue of Nagas, for instance. The state of Nagaland, if we remember, they were not having a politically organized central administration as Manipur did. So, with Manipur as a historical and political reality, which has also been given acknowledgement and recognition in India's constitution, it is not very difficult for the politicians and the leaders of Manipur to bargain on that basis, on that constitutional basis, with India for more autonomy or for more dignified position of Manipur within the Indian political system. So I would like to answer this in this way.
Okay, thank you. We have two more questions. One is from Rajkumar Panthorian. He asked, is the constitutional provision for Sikkim, that is Article 371F, unique? How can we understand its clause M? Neither the Supreme Court nor any other court shall have jurisdiction in respect to any dispute or other matter arising out of any treaty, agreement, engagement, or other similar instrument relating to Sikkim, which was entered into or executed before the appointed day, and to which the government of India or any of its predecessor governments was a party. But nothing in this clause shall be cons- construed to derogate from the provision of Article 143. This is a very long question, and yeah, how will you break out that? Sir, please
Mm,
go ahead.
yes. So yes, this is similar. This provision is similar if you look into Article 363 of the Constitution of India. The Supreme Court of India is prohibited from having any jurisdiction over any treaties, agreements, sanats with the then British India government. So it is like that. In one sense, I can take this question as also applicable towards Manipur when the issue of merger agreement comes up. Say this uh, provision of the Constitution, Article 368, prohibits the Supreme Court from taking up any claim or interpretation or contestations that come out of any treaty or agreement or sanat that took place with the British government. So here, one point is very clear. When the Constitution of India says that the Supreme Court of India do not have jurisdiction, it means that the Supreme Court is not the proper forum. It is not the correct, appropriate forum for such kind of matters. And if we look into the way in which the princely states entered into relations with British India, before Indian Independence Act was implemented. The nature of the political status that the princely states enjoyed during the British rule before 1947 is very important here. In international law, a treaty or an agreement can be entered into by two or more independent entities, that is, sovereign independent states. So when we say princely states, we need to understand the meaning of state uh, from an international politics, international law perspective, that is, sovereign independent states, not the states as administrative units that we have in India at present. So the states during the British administration in India were politically independent and sovereign states. So they had numerous treaties and agreements. The relation between British India government and the princely states were based on these treaties, agreements, and sanats. For example, in the case of Manipur, if we look into the 1762 Treaty of Alliance and Defense, it was a treaty that makes both the parties, British as well as Manipur, to provide assistance to each other in case of fighting or defending against the common enemy that was Myanmar, Burma at that point of time. So uh, it was there, and then the Treaty of Yandavu, 1826, is there. These are treaties that define the nature of political relationship between two entities. So this is one element that inform us about the status of the states during British India. And if we come into the dominion of India around 1947, the status of the princely states, I have mentioned this a few minutes before. The status of these states were reaffirmed by the Supreme Court of India beginning 1953 to 1994. There have been several cases in order to ascertain the exact political legal status of these princely states at the lapse of British paramountcy. So the Supreme Court of India had reaffirmed time and again that all the princely states at the lapse of British paramountcy in 1947 were independent and sovereign entities. And because of that, we must remember that not only with the British India, but at the lapse of British paramountcy, the princely states had entered into negotiations and acceded to the instrument of accession towards joining the Union of India. They have entered into merger agreements with the dominant government of India. So, entering into agreement, acceding an instrument, joining the Union of India is an act of exercising that political sovereignty, the character of an independent entity. The sovereignty of the state is exercised, is manifested in concluding agreements. So, by these points, we come to know that all the princely states, and even including Manipur, Tripura at that point of time, they were sovereign independent states. So we can say that with this question, Indian authority, Indian tribunals, including the Supreme Court, is not a competent tribunal to try such cases. It's outside the scope of the Supreme Court. It is outside the scope of the Constitution of India itself. It is only appropriate to be submitted to an international tribunal. So we have 1945 United Nations Charter, of which India is also a member since 1945. So there are many options. There are many forums for addressing such issues. I would like to answer in this way.
Okay, thank you. I'll take up this last question, then we'll try to wind up if nobody has any question or comment. And this last question is by Vaikom Sena. He asked, if it is possible, sir, could you throw some lights on MLR-LR Act 1960 and demanding of scheduled tribe by Meitei?
Yes, this MLR and LR Act 1960, we see the year in which it was passed. It was passed during a long period of time when Manipur people did not have its own elected representatives. It was an act of the parliament. So by this act, the people have been divided. We can say division socially, and then especially social division is implemented by this act. So what can we do now? There are again constitutional provision. Any parliamentary law met by the center during proclamation of emergency can be reversed by the state government. There is a procedure. The state government has to initiate the state government has to make use of the provisions of the constitution in order to reverse past wrongs, like the MLR Act itself. So MLR Act itself is very undemocratic, and the power is with the state government in consultation with the respective stakeholders of various communities. It can be modified, it can be made democratic, and it is not the end. Let us not forget that having a law does not mean that it should be always like this, as the law has met. The law can be modified. And sixth schedule, scheduled tribe status by the Meiteis, it is not a problem to demand something, because this is a status guaranteed under the Constitution of India. But I think the controversy amongst the Meitei itself is regarding certain, disadvantages, or accepting the social stratification under the Constitution of India. See, before the before Manipur became part of India, we do not have this social and political categorization of people, even though the words like the connotations of tribe was there, but it was not to the extent that we see in certain tribal regions of mainland India. In the context of Manipur, this idea, thinking that having scheduled tribe status would be advantageous towards the Meitei community, is informed the way the Indian Constitution has accommodated community-based, caste-based privileges. But if we look back into the polity of Manipur, the 1947 Constitution of Manipur, we do not find any such differentiation of people on the basis of caste, community, and ethnicity. So maybe we are also informed by certain advantages that in terms of employment, in terms of education, the scheduled tribe status would help us. But there are also other considerations, some quarters on coming up with the idea that Meiteis obtaining the scheduled tribe status would be like degrading our political status that we had existed as independent country, and Meiteis had always been at the forefront of preserving the identity and the integrity of Manipur. It seems that conflict is part of that issue on scheduled tribe, but legally there is no problem as per the constitution. I would like to answer this way.
Okay. I thought that will be the last question, but one of the participants have asked another question again. This is regarding to the merger agreement. So what are the key consideration and potential steps for assessing the legality and viability of ceding Manipur from the 1949 merger agreement amid alleged Indian Union violations?
Okay, when we say undoing the merger agreement, for example, in other words, how can we undo the merger agreement? It's a political as well as a legal process, I should say. Political in the sense that the government of India has taken a very different position with respect to the questions of Manipur, the questions in Tripura, even Assam, Nagaland also, in Mizoram also we have seen, and even with Jammu and Kashmir. So if we see, the government of India has declared a reservation towards Article 1 of the International Covenant on Civil and Political Rights. Article 1 of this civil and political rights talks about the right of self-determination of all peoples. Here, the government of India has taken the position that it do not recognize this right except in colonial situations where there is foreign domination. So India do not consider situation in Manipur, in Kashmir, in Nagaland, in Mizoram and Assam as colonial situations. So to that extent, Article 1, India's position is very clear. It do not recognize the right of self-determination. Second point is about when we talk about the legality of the merger agreement, there are international instruments of international law from which we try to understand whether the agreement was concluded with fairness from the principles of international law, procedural fairness, as well as the political element of the merger agreement, meaning thereby whether the confidence of the people of Manipur had been obtained by the Union Government of India before the merger agreement or after the agreement, like holding a plebiscite, uh, allowing the people to vote, to exercise their determination, how they want to determine how they whether the people of Manipur in 1949, or for that matter in any of the time after integration, have not been allowed this exercise, this right to freely determine their own wishes whether Manipur wants to be a part of India or not. So plebiscite is one such option, or we can say forum where Manipur people can express their wishes, their aspiration of what they want to be with India or without India. And maybe there are other principles and forums under international law where these issues can be pursued. So it depends upon the people, it depends upon the politics of the region. I would like to answer like this.
There are no questions left in the chat box. If anybody wants to say something on comment, you can feel free. If not, then we'll end the session. So thank you so much, Ozam Malem, for enlightening us with many of the intricacies that surrounds the center-state relation, and yeah, and doing far more justice to the topic today, far more than justice, I should say. And yeah, so we really appreciate from our library your intellectual and academic rigor. Yeah, thank you so much for enlightening us, and also to all the participants who have raised some of the critical questions regarding the topic today. And Ojam Malam, we appreciate you, and our library team hope to interact with you in the near future as well. Thank you so much for today's talk. Yeah.
Okay, thank you. I do not know I have done justice or not, but I tried some, points that we always try to we always try to misread or take them for granted, especially referring to history. When we talk about 1947, 1949, there are many perspectives that I have encountered and experienced, that even speaking about all these historical realities are considered, like they have the feeling that they would be taken as anti-national. No, it is not that. If we are talking about historical and political realities based on which we are now experiencing our day-to-day life. So we are informed of these historical realities, our lives, our perspectives, our politics, and our survival. The challenges that we face today, what Manipur is facing today, are based on these historical political realities. So we need not have any, those kind of apprehensions. We have a right to discuss about our existence, about our politics, about our society. And thank you. I do not know whether I have done justice to answering and giving to all the questions. Maybe we continue the interaction in many forums through writing and through interaction. Thank you for having me here. Thank you for all your questions.
Yeah, thank you so much, Roja. Like, hope we'll meet again. Yeah. As a
Okay,
young
sure.
scholar, I mean, it's much of an enlightening experience, and I know that the amount